Okay, welcome everyone, and thank you for joining our webinar about the future changes of employer skill migration program. Now, these presentations are intended for educational and purposes only and do not replace independent professional judgment. Statements of fact and opinion expressed are those of the participants individually and unless expressly stated to the contrary, are not the opinion or position of Alex Halim and Associates, its co-sponsors, or its team. Alex Halim and Associates does not endorse or approve and assumes no responsibility for the content, accuracy, and completeness of the information presented. Attendees should note that sessions are audio recorded and may be published in various media, including print, audio, and video formats without further notice. Now, my name is Alex Halim. I am the principal of Alex Halim and Associates. And yes, that is me in the pictures. I'm sorry about the hairs. For me, that's the hairstyle during that event. For some reason, my hair standing up. And I will be presented today. Now, before I start, let me briefly introduce my practice and my team. Alex Halim and Associates is established in 2005. We are a registered migration agent firm that provides accurate, honest, and reliable migration solution to our clients. So their migration process to Australia become easier and successful. Migration strategy, assistance with Australian visa, corporate sponsorship, refusal decision appeal, and maintaining permanent residency strategy are the type of migration services that we have successfully provided to our clients since 2005. So now let's continue with the topic of today's seminar. The future changes of employer-sponsored visa affect both temporary as well as the permanent. As you may aware, temporary work 457 will be replaced by a temporary skills shortage, or called TSS, this month. Like temporary 457, TSS will have 3 processes of approval for new sponsorship application, and the nominated occupation for this visa must be at least in either on the medium long-term strategic skill list, MLTSSL, or on the short-term skill occupation list, STSOL. The first process is the approval of standard or credited sponsorship process. The second process is the approval of medium long-term or short-term nomination process. And finally, the approval process of the visa. Stream of TSS visa approved will be depending on the approved nomination. 4 years for medium long term and 2 years for short term. So let's go through the positive changes and the negative changes for each approval process. I'm going to start with the positive changes because we always look forward to positive changes. There are 3 positive changes to the sponsorship approval process. 1, the approval will be 5 years standard. This means, unlike the current 457 sponsorship approval, startup company only get 18 months sponsorship approval. In the future, they will get 5 years. 2, it can be renewed 2 months before the approved sponsorship expires. 3, renewal process may be able to be approved within 5 minutes. and there are no negative changes to the sponsorship approval process. While for the nomination approval process, there is only positive change, only one approval, positive change to the nomination approval process. And I believe it is a positive change that will benefit all participants, all applicants and sponsors. The nominated occupation only assessed at time of nomination application. This means if the nominated occupation either move from medium long-term occupation list or to the short-term occupation list or remove from all lists together, it will not affect the validity of the nomination application. This creates more certainty for the applicant in the comparison to the current FOFA 7 nomination approval process. Now, let's have a look at the negative changes of the nomination approval process. There are 3 negative changes. 1. Labor market testing is required for all applicants, with exception of talent applicant, which will be determined by the department. 2. Gumtree advertising is no longer acceptable to satisfy LMT. 3. Skilling Australia Fund, or SAF, levy will replace the training benchmark, and this levy needs to be paid upfront. The levy for TSS is starting from 1,200 per annum per nomination. So next, let's look at the positive changes of the visa approval process. There are 5 positive changes. 1. The path for a permanent visa still available for the TSS visa holder. 2. Whether skill assessment required for certain nominated occupation will become more certain because it will be stated in the legal instrument rather than the policy, which makes it currently it depends on the Department of Home Affairs. 3. The minimum visa grant for the TSS is 12 months. 4. Bridging visa A, B, or C holder does not need to go outside Australia in order to apply TSS visa while in Australia. And the last positive changes, the department promised 2 months fast-track processing time for decision-ready application with clear submission. And this has been our practice standard since 2005. Now, finally, the negative changes of the visa approval process. There are 6 negative changes. 1. Introduction of annual market salary rate, or AMSR, in addition to the temporary skill minimum income threshold of TSMIT. 2. Primary visa applicant must have at least 2 years of post-qualification employment experience related to the nominated occupation. 3. Short-term TSS only can be granted twice in Australia. For the third application, the applicant must be outside Australia. 4. No more health waiver. All applicants must meet health criteria for grant decision. 5. Changing occupation will require a lodgement of a new nomination application, and a lodgement for new visa application. 6. Short-term TSS applicant will need to satisfy the genuine temporary entrance requirement. Now, I am going to move forward to the permanent visa of the employer sponsor. There is no new subclass for the permanent visa for employment sponsor. Employer nominated scheme (ENS) and regional sponsored migration scheme (RSMS) continues to be valid after March 2018. There are two positive changes for ENS and RSMS visa. 1. Transition arrangements, which I will explain further in a later slide. 2. Training obligation. The assessment is at the nomination application for the permanent visa. Let me repeat that again. There is no training obligation assessment at the nomination application for the permanent visa. And I will tell you why in the later slide. There are 5 negative changes to the ENS or RSMS. The first one is the one-off SAF levy, starting from $3,000 per nomination. And because of this levy, at the time of nomination for the permanent visa for ENS or RSMS, the department will not look at whether the organization has met the training benchmark in the last 12 months because of the SAF payment at the time of the nomination. 2. Reduction of age. The age of the primary visa applicant must be under 45. 3. Only TSS with medium long-term nominated occupation can apply for ENS or RSMS. 4. For TSS visa holder to transition to the permanent ENS or RSMS, the applicant must hold TSS visa for at least 3 years and working for the same employer during those periods. 5. The salary condition follows the TSS salary condition rather than market salary. Now, for some of you that currently hold 457 visa, you want to pay attention to the next 2 slides. Transitional arrangement only applicable if you meet any of these conditions. 1. You hold a 457 visa granted on or before the 18th of April 2017. Or 2. You hold a bridging visa while waiting for 457 visa application lodged on or before 18th of April 2017. Hence, if you meet any of these conditions, you will have access to the transitional arrangement, which allow you to apply the permanent ENS or RSMS transition stream without your occupation, whether it's listed in the medium long-term skill list or the short-term skill list. You're also able to apply under this permanent visa, ENS or RSMS, when you have not turned 50. And the minimum employment period as the holder of 457 visa or TSS visa remain 2 years, rather than 3 years, as I mentioned in the previous slide for for the new visa applicant after that particular date. So let's recap. Certain 457 or TSS visa holder still have access to transition arrangement after March 2018. There is two types of TSS visa, which is long-term and short-term. TSS short-term only can be granted twice in Australia, and GT requirement applicable to this visa stream. Skilling Australia Fund, SAP levy, is replacing training benchmark, and it needs to be paid upfront. Now, I'm sure that you have prepared a lot of questions, I hope. And because of time, I'm going to answer only selected questions. And if you have any other questions, I recommend you consult with us further. Now I'm going to enable the chat function, and you're welcome to type in your question in this chat function. All right, the chat function is open, and you're welcome to type in your questions. Thank you, Alice, for your questions. The question is, what if occupation move from short to medium list? If the occupation moves after the nomination application is applied, then the changes will not be applicable to you. But if the changes happen after the nomination is approved, and for example, the occupation was in the short and then become medium, then I would suggest to submit a new nomination application and a new visa application, so to make sure that you have access to the permanent visa after the new visa application is granted. I hope that answered the question. Any other questions? Second question, what do you mean by talent applicant to be exempted from LMT? This is what I understand from the Department of Home Affairs when I attend their seminar. What they mean by talent applicant is an applicant that is very unique in certain skills, and they can see that it is quite impossible to have another person replace the skill of that person. However, they said that they will look at the talent applicant to be exempted from LMT on case-to-case basis. So it is all depending on the department judgment at the end of the day. All right, you're welcome. That's good. Any other questions from Emma? Or welcome, Emma. Okay, a question from GM. What is the procedure to include my partner, not my wife, in my visa once I get the permanent residency? GM, to answer that question, you will need to show to the Department of Home Affairs that your relationship with your partner met the definition of spouse under the Australian migration law. If that condition met, then after your permanent residency is granted, the only pathway to apply a visa pathway to apply for her, or will be a partner or spouse visa. No worries. Thank you, Guillaume. Okay, what is the amount of self-levy and what do you mean by paying it upfront from Alice? Okay, self-levy, it's it depends on the size of the turnover of the business. For example, business with a turnover less than $10 million. So this is I'm talking about the TSS self-levy. The indicative levy is 1,200 per nomination per annum. So which means that if the nomination is aiming for a medium long term with validity of 4 years visa, the Department of Home Affairs will require the payment of 4,800 upfront in addition to the nomination application. That's what it meant by upfront payment. A question from Usman Wijajabon. I don't quite understand. Are you referring to VETASES or visitor visa? If you are referring to VETASES skill assessment, yes, the skill assessor does not need you to have English requirement in order to meet or to gain a positive skill outcome from them. You need is basically the qualification highly relevant to be nominated occupation, and you must have at least 12 months post-qualification employment experience in the last 5 years before applying the skill assessment from VETASES. So I hope this is what you mean. Question from Alice, very good question. Can SEF be paid by the visa applicant? The answer is a big no-no. The Department of Immigration is actually putting that under the law. They will consider payment by the applicant for the SEF levy, which means it's considered as a way for the nominator to recoup money from the applicant and try to sell the sponsorship. Therefore, the answer is no. Question from Emma. If we have an existing 457 visa holder, do we then have to apply self-levy for the remaining years on sponsorship? The answer is yes, Emma. Once the levy pass the parliament or become legislative as a law, at this stage, the actual levy has not become a law because they still try to work on the frameworks. Until then, the current training benchmark or training obligation will continue. You're welcome, Emma. Okay, answer a question from Guillaume. How long should I start all applicants and all the application works before my 457 end? Do you mean when it is a good time for applying the permanent visa before your 457 end? My recommendation to all of my clients is if they are looking for pathway to permanent residency, as soon as they pass the 2 years or meet the 2 years requirement to transition to the permanent visa, I would recommend to start preparing as soon as possible when that 2 years period is met. Question from let me see panel. Okay, question from Victor. What is the situation for accountants? You need work experience for 190 visa. 190 visa is not covered in this presentation. However, I will answer that question, Victor. Um, 190 is totally different program. It's not an employer sponsored. It's actually a state nominated sponsor. And it is depending on the invitation from the state. And unfortunately, the state does not disclose any information of how they choose the invitee. They just basically, or the nominee, they will basically just invite without notice, and they will not release the number of invitations they have released for certain occupation. Um, I mean, for all occupation actually by the state. So the market situation, I think a lot of accountants already existed, and there's not enough employment to absorb accountants. Hence, I think that's why there is a hold up from the state nomination as well as from the skill independent from the invitation from the Department of Home Affairs itself. Regarding experience, you have to check on each state's requirement. Each state has different requirement. For example, New South Wales, it does not require you to have an employment experience or employment offer, but some states like ACT or Victoria or Tasmania or Northern Territory, they have different requirements. Question from Emma Ross: how will employer be notified when the self-levy has been improved and when to implement? To be honest, I'm not sure how the Department of Home Affairs going to notify the employer. But if you are our client and you subscribe to our newsletter, the notification will be published in there. Okay, question from Alice: is self-levy able to be refunded if the nomination is refused or when the sponsored worker moves to another sponsor? That is a good question. Whether it's going to be refunded when the nomination is refused, according to the officer that presenting the presentation during the seminar by the Department of Home Affairs, when the nomination is refused, the levy will be refunded. However, when the sponsor move from one sponsor to another, that is not clear yet. Based on the question that I asked during the seminar, the answer is no. But this is yet to be confirmed because the legislation for the levy is not out yet. Question from GM: once the permanent residency has been approved, how long do I have to stay working with my sponsor? Will I be allowed to create a new company? How long do you have to stay working with your sponsor? It is an arrangement between you and the sponsor. However, there is an obligation from the sponsor to say that the sponsor need to make sure that the employment or the position will exist in the next 2 years. So as long as the position that is presented in the nomination is genuine and the reason that you actually move job or move employment is reasonable, I would not see any. I don't see any issue with that. Now, in regards to whether you're allowed to create a new company, yes, of course. Once you are permanent residency, you are treated as local. Question from Emma: is the staff levy part of the wages, therefore taxable? The staff levy is not part of the wages; it's a separate, but it is taxable. Usman, I think your question is better for me to discuss privately. Another question from Alice: what happens to the nomination application that is currently in appeal tribunal after March 2018. If the nomination application that is refused and is appealed in the tribunal, but there is no visa application that is linked to that nomination appeal as well in the tribunal, uh, there is a higher chance that the nomination will expire and it cannot be relinked with the new TSS visa. But if the nomination and the application is in the appeal, then it will still use the previous framework and is considered as a transitional arrangement. You're welcome, Alice, and you're welcome, Emma. GTE. Okay, what is considered as GTE? Based on my understanding of the GTE for the purpose of TSS, they will look at how long have you been in Australia in the last, say, 4 years. Um, what have you been doing? And they also will see whether the position is genuine, whether it's created for the purpose of to prolong your stay, and also they will see how many TSS has been approved to you. If you are on the second TSS application, the chance of GTE requirement is higher. When you have the second TSS visa application approved and you want to apply for the third one, the most likely you will not meet the GTE requirement. Therefore, I mentioned in the previous slides that when you want to apply for the third short-term TSS, you will need to apply from overseas, but it may not be approved. It will be depends on meeting the GTE requirement. You're welcome. Is there any other questions? If there's no further questions, Usman, as I said to you, I will answer that question personally, and it is better to consult, to discuss that matter offline or outside this seminar. All right, if there is no further questions, I would like to thank you all for attending this seminar. And if you'd like to consult with us further, you can contact us by phone or email or website, which is as you can see on your screen. And I hope you have a wonderful day with the rest of your day. Once again, thank you. And don't forget to complete our seminar survey, which is basically will appear after this seminar ended. Thank you.